colleagues, please take a seat. We continue immediately. And it is a great pleasure for me to welcome Mr. Mark Meyer, Chair, City Bar Council on International Affairs, and the recipient of Romania's Order of Merit, so rank of Commander, and also Moldova's Medal of Civic Merit. He's a Honorary Consul of the Republic of Moldova for the state of New York. So he has a great experience in consulting in these countries, and it's a great pleasure and very, very interesting for us that he is here with us and he shares his experience and knowledge on that with us. So, Mr. Meyer, please take the floor.
Thank you, Professor. I had commented to the professor earlier how impressed I was that every speaker that spoke in the last panel, he had a cogent remark on what they had to say. And I thought they were excellent remarks, and that's a unique skill that I don't have. What I'd like to talk to you about for 5-6 minutes is my own experience with respect to bringing the rule of law to countries in transition. I'm going to talk to you about Romania and Moldova because that's my experience. But that experience translates to almost any country that is in the process of transitioning from a totalitarian regime to a democracy. The interesting question is, why does it take so long? Why in Moldova are we still talking about a transition? Even in Romania, which has made tremendous strides, we're still talking about transition. So I just in touching on some of the issues that are involved in attempting to reform a legal system and institutions, what these countries are faced with in the first instance is a historical experience of authoritarian rule. It is not something that is easy to overcome. You cannot go from having been subjected to an authoritarian regime and to all that means, and then suddenly find yourself dealing with a democratic institution. It doesn't work. And why doesn't it work? In the case of both Romania and Moldova, there are a number of factors. One of them is, of course, the most pervasive and serious, which is corruption. Corruption in the judiciary, corruption throughout the institutions, the governmental institutions. And how does that really affect the average citizen? You can't get anything done, at least you couldn't, in the early days, in the 1990s, in the early part of this century, in these countries, without having to deal with the issue of corrupt officials, corrupt courts. It's very hard to be a judge and be honest when your next door neighbor, also a judge, is driving a Mercedes, their kids are properly cared for in private schools, and they have vacations and other things, and you look over at them and you wonder, why am I, what am I doing? Part of this also comes from this top-down authority issue. In Ceausescu's Romania, nobody did anything unless they were told to do it from important people at the top. That didn't change on December 25th, 1989. It didn't change. It required years and years of effort for people to actually do their jobs. Why? Because not doing anything had no consequences. Doing something that possibly might be wrong, might be an error, did cause people problems in administration. So another problem, equal in both Romania and in Moldova, and unfortunately, despite the Herculean efforts of the Moldovan government under President Meyer, it's still a problem, and that's organized crime. And organized crime affects the rule of law because it permeates throughout the system. These countries, as they are in transition, have weak judiciaries. What else would you expect? You can't make these transitions with people, again, who don't have the experience of working in a free environment, in a system of rules. A problem that persists in Romania and continues in Moldova is the perception that corruption is still there. I can tell you that corruption in Romania now, yes, of course it's there. It's here in New York. It's everywhere. But corruption in Romania is nothing like it was in the 1990s. And the efforts of the government and now the courts in Moldova to attempt to deal with corruption, not easy, but they're trying. Why isn't it easy? Well, one thing in Moldova that Romania fortunately has not had is the invasive efforts of the Russian Federation to control so many aspects of Moldovan life that and fund the most corrupt elements. We had Judge Manoli was speaking about the Shore Party. I mean, there's an example of a totally corrupt individual who is wanted in Moldova, has sanctions imposed by the United States, who's living in Israel because of, you know, the right of Israelis not to have to be extradited, and is manipulating the Moldovan legal system. Moldova also had the problem of Transnistria, thanks to the Russians, and also thanks to the Russians, the problems in Gagauzia. They persist today, and it's very hard for a small country like Moldova to have to deal with the problems that the Russians create for them on a daily basis. And part of those problems is whipping up ethnic tensions that frankly didn't exist until the efforts of the Russian Federation to promote them. And that's the issues that are between Romanian speakers, Russian speakers, Ukrainians, the Gagauz. And then, of course, just in closing, there's a lot more that I can say about this, but in closing, the economic hardships. Neither Romania nor Moldova had wealthy people. They had poor people, and they did not have the economic capability to easily move them up. It's happening slowly in Romania, but we're talking about 30 years. Moldova to this day is still the poorest country in Europe. And that's not because the Moldovans are just a bunch of peasants. They're not. It's because of all these factors that we're talking about, and they impinge upon the rule of law. So if we ever get to a dialogue, I'll be happy to, speak a little bit more on it, but I very much appreciate this opportunity, and particularly on behalf of the New York City Bar Association. Thank you.
Thank you very much, Mr. Meyer. It was an honor and pleasure to listen to you, and you have great experience, and you are considering the developments in these countries also today. And yeah, thank you so much. So fine. But now we have to go on, and next speaker would be Professor Viktor Muraviov, and after him, Professor Mircea Criste from Romania. So please, dear.
So I'm going to speak about constitutionalism in Ukraine in time of war. So when we talk about constitutionalism in Ukraine, we should bear in mind that Ukraine, unlike Russia, as a country with age-old constitutional traditions, in time of war with Russia, Ukraine has become a sentinel that guards the area of democracy and a rule of law from the area of dictatorship on its eastern and northern borders. The first Ukrainian constitution was written back 1710 by Ukrainian hetman Philip Orlik. It was called the Constitution of Philip Orlik, or Pacts and Constitutions of Rights and Freedoms of the Zaporozhye Host. The Constitution of Independent Ukraine was adopted in 1996. The Constitution proclaimed that Ukraine is a rule of law state. Under the 1996 Constitution, Ukraine has become a presidential parliamentary republic. The Russian aggression against Ukraine was launched in February 2014. The war with Russia subdivided constitutional development in Ukraine in two periods of time. The first period lasted from February 2014 till February 2022. It was characterized by the war of low intensivity, when Russia occupied some parts of the Ukrainian territory and tried to hold on them by shelling the territory of the independent Ukraine. At that time, the constitution was amended for the third time in 2014 as the result of the struggle for the change of the balance of power between the president and the parliament. On the other hand, in March 2014, Ukraine signed the association agreement with the European Union. The agreement referred to the common values of the European Union, and they became an integral part of the Ukrainian legal order, and Ukraine has become a value-oriented state. In time of the war of low intensivity, Ukraine continued its constitutional reforms. The most important of them was the judicial reform. In 2016, the parliament adopted the changes to the constitution in the sphere of justice and jurisprudence. In 2019, Ukraine's constitution was amended once again with the entry into force of the law regarding the strategic course of the state for acquiring membership of Ukraine in the European Union and in the North Atlantic Treaty Organization. On February 24, 2022, Russia resorted to the large-scale aggression against Ukraine. The martial law was imposed in Ukraine by the decree of the president. It was extended several times. The war and the adoption of martial law have created changes in the Ukraine's constitutional development. Article 157 of the Constitution asserts that the Constitution may not be amended in the conditions of martial law. At the same time, according to the decree of the President, the constitutional rights and freedoms of individuals and citizens provided for in some articles of the Constitution may be temporarily restricted during martial law concerning inviolability of home, secrecy of correspondence, non-interference in private and family life, freedom of movement of people, etc. At the same time, even under martial law, there is a number of those basic constitutional rights and freedoms which are not limited and guaranteed by the Constitution. Such rights include equality of constitutional rights and freedoms and equality before the law, the right to respect for dignity, the right to liberty and security of persons, the right to judicial protection, etc. Despite the martial law regime, the Constitutional Court has continued its work, though on a limited basis. In particular, the granting of a EU candidate status to Ukraine has required from the state to embark on a new set of reforms to meet the European Commission's conditions for the beginning of the negotiations on the accession to the European Union. First of all, it is ensuring an independent judiciary. Conclusion. Even during the war with Russia, the flywheel of the constitutional reforms in Ukraine does not subside. Every president wants to leave his mark in the history of the country by amending the constitution. As a whole, there are two major approaches which are discussed by major political players: making changes to the current constitution or developing a totally new basic law. The first one is to continue constitutional patchworking by realizing some post-Maidan changes which were not adopted. They are decentralization of state functions, strengthening the status of farmers, etc. More radical proposal entail adopting an absolutely new text rather than tinkering with the current one. In particular, some of the reform proposals are aimed at empowering an already powerful presidency and de facto result in the establishment of a presidential system in Ukraine as opposed to the formal semi-presidential system. Thank you.
Thank you very much, dear Viktor, for telling us how, whether there is a conflict between the value orientation, which is necessary for Ukraine, of course, as a candidate state for the European Union, and maybe the law of war. But as I understood, there are no decisive interventions now into fundamental rights or so. So this is conformed to the traditional pattern, yeah, this is interesting really under this point of view. Thank you so much. Now, Professor Mircea Criste. Yes, so Professor Criste is a Deputy Ombudsman of Romania, and you have a microphone. Yeah.
I think it will work, yeah. Thank you, Mr. Chair, distinguished colleagues. I am equally pleased and honored to be back in such a select gathering, and I wish to thank the organizer for inviting me and offering me the opportunity to speak before you. On the occasion of the 21st International Congress on European and Comparative Constitutional Law, I approached the topic of the rule of law as protected by the Romanian Constitutional Court's case law by referring to a specific aspect, namely the resolution of legal conflicts of a constitutional nature. The rule of law represents a standard, conditioned by the verification that the characteristics of a democracy are met. Although we can also find in totalitarian states the requirement of strict observance for the rule adopted according to prescribed procedure, we cannot speak in such situation of rule of law, since we are merely in the presence of a normative state as opposed to the anarchic one. This is the reason why a totalitarian state, exempli gratias the Stalinist state, is said not to be governed by the rule of law or not to promote the rule of law. The qualification is made almost automatically by reference to the fulfillment of the criteria underlying a democracy. The material prepared for this Congress refers to the rule of law in the light of the Constitutional Court's case law, defining and protecting the separation of powers, the principle of legality, the independence of justice, the legitimacy and limitation of power, and the constitutional protection of fundamental rights and freedoms. The Constitutional Court decision, which refer to the manner in which each of the above-mentioned aspects through which the rule of law asserts itself is protected, will be presented in detail in the article to be published. In this presentation, I will only refer to the consideration extract from some of these decisions. The separation of powers is a defining principle for the existence of the rule of law, which allowed, as it did more than 200 years ago in the United States, for the foundation of the constitutional review of laws in Romania. First, by means of famous decision of the Court of Cassation pronounced in the tramway company trial of 1912, then after the fall of the communist regime, by means of the decision of the Supreme Court in January 1991. The Constitutional Court of Romania, created through the 1991 Constitution, also affirmed the principle of the rule of law from its very first decision, when it declared unconstitutional the legal provision that stipulated the suspension of the trials on nationalized assets until their legal settlement. The Parliament's interference in the course of justice was considered by the constitutional judges as a violation of the principle of separation of powers, even so the latter was not expressly mentioned in the Constitution as it stood before the 2003 revision. The principle of legality is also linked to the affirmation of the rule of law, expressing two requirements of the rule of law. The obligation of all subjects to respect the legal rules in force, as well as to respect the hierarchy within the national normative system. According to the Article 147 of the Constitution, the provision of laws and ordinances in force, which are found to be unconstitutional, shall cease their legal effects within 45 days of the publication of the decision if, in the meantime, the Parliament or the government, as the case may be, have failed to bring the unconstitutional provision into line with the Constitution. For this limited length of time, the provision found to be unconstitutional shall be suspended de jure. Protecting the rule of law from this perspective, the Constitutional Court ruled that the situation created by the passivity of the legislator following the publication of a decision admitting a plea of unconstitutionality amounts a disregard of Article 1, Paragraph 3 of the Fundamental Law, which enshrines the character of the Romanian state as a state governed by the rule of law. This is because the prevalence of the Constitution over the entire regulatory system is a crucial principle of the rule of law, or the guarantor of the supremacy of the fundamental law is the Constitutional Court itself, through the decision it pronounced, so that neglecting the findings and provision contained in its decision weakens the constitutional structure that should characterize the rule of law. This conclusion is also valid for those decisions through which the court settles a legal conflict of constitutional nature. The authority that generated the conflict having the obligation in the framework of the rule of law to respect and comply with the findings of the Constitutional Court decision. By emphasizing that the ex nunc effect of the court decision constitutes an application of the principle of non-retroactivity, the latter is defined as a fundamental guarantee of constitutional rights, which is likely to ensure both legal certainty and the citizens' confidence in the legal system, a prerequisite for observing the separation of power and thus contributing to the consolidation of the rule of law. The respect of the rule of law implies an application of the implicit and formal provision of the law and the Constitution, but it's not limited to this component, since it also implies constitutional behaviors and practices on the part of public authorities. The Court stresses in this context the importance for the proper functioning of the rule of law of the cooperation between the powers of the state, which should be conducted in the spirit of the rule of constitutional loyalty, the loyal conduct being at the heart of the rule of law. As the Venice Commission has also pointed out, the rule of law is a concept of universal validity. However, the full achievement of the rule of law remains an ongoing task even in the well-established democracy. A special case is constituted by the situation of the young democracy that emerged in the Central and Eastern Europe following the collapse of the communist regime. after half a century of totalitarian political rule, they are discovering the democratic values of the concept of the rule of law, demonstrating a real commitment to its affirmation through an elaborate and enduring process to the development of which the constitutional courts make a substantial and decisive contribution. Thank you very much.
Thank you very much, dear Mircea. Yes, yeah, I feel guilty that I have given you the imposition only 7 minutes, and so you are. No, I did not want to hurry you up so much, but no, it was very interesting, your analysis of the jurisprudence and the text and as seen by jurisprudence of the Romanian Constitutional Court, and you mentioned also that Council of Europe or the Venice Commission is of the opinion that rule of law is a universal thing. Yes, so I fully agree, of course, with this. And but we see that rule of law is anchored in the text and in the spirit of a constitution, I think of every constitution. But what is necessary, and we are striving for this, is that a culture, a rule of law culture comes up in the society. And this is then the fundament against attacks from outside or from also authoritarian tendencies and so on. Okay, thank you so much. Now it's my pleasure and honor to give the floor to Professor Sergiy Maksymov from the National Law University of Kharkiv. And we are in close contact since my last visit in Kharkiv, and so this motivates me also to finish my article for your journal. So, dear Sergiy, please take the floor.
Thank you very much. I apologize for some metaphysics in my speech because I am a philosopher in my first education. Universality of the rule of law is not limited only by wide empirical prevalence in the world. It is mentioned in constitution, laws, decision of the judiciary, etc. Rather, it is about its deeper meaning as an essential value, cultural acquisition of all mankind. The rule of law is not an eternal idea, but having arisen at a certain stage in mankind development, it has become an eternal idea or universal as in time and in space measures. Ukraine does not belong to countries with a development system of the rule of law. It rather seeks to establish such a system in itself based on experience of more legally developed countries. However, Ukraine does not approach this process empty-handed. Own experience, own inspiring expectation, certain achievements and bitter disappointments, and its individual experience on the path to rule of law will be important to confirm thesis of universality of this idea and practice. As a result of Russia's full-scale aggression against Ukraine, its citizens have shown their courage, resilience, and organization. At first glance, the main task is not establishment of the rule of law, but mobilization of all resources to fight the enemy by any means. This is true, but still the task of organizing life on the basis of the rule of law is not relegated to a later period when victory over the strong and dangerous enemy will be ensured. Although positive steps in the direction have slowed down, they have not stopped. Rule of law, along with a normative institutional component, also has a non-institutional or cultural one. Usually, first of all, attention is paid to institutional component, separation of powers, independence of the judiciary, and other provisions that are recorded in the documents of international organizations, including the Venice Commission. Of course, the formal component is important. After all, even simply following the indicated points of the checklist will allow you to list outwardly, not to drive on the left side of the street when everyone drives on the right. Already at a simple everyday level, interpretation and attitude to rule of law is different. Different cultures differ. In 2009, Beijing hosted the 24th World Congress of the International Association for the Philosophy of Law and Social Philosophy on the theme Global Harmony and Rule of Law, in which I was a participant. At the door of the hall where the plenary lectures were held, a young security service soldier was stationed who did not let the participants of the Congress into the hall without badges. To the surprise of some representative of academic community who forgot or simply left their badges in the room, the young man pointed to a poster with the name of the Congress and said with a smile, "Rule of law." Another example is the attitude of ordinary Ukrainians to the need to comply with the rules in accordance with the principle of rule of rules, not people. In Vienna, at the berth with cruise ships, I met a sailor of the Ukrainian ship at the port of residence of Izmail, the mouth of the Donau. To my remark that I like living in Vienna because everyone strives to follow the rules, I hid the objection that he did not like such a life by the rules. However, after my simple arguments that it is a much more convenient and economical when you do not puzzle over that gift and in what form you need to present to a doctor, teacher, or official, he agreed with them. This case is simply paradigmatic. A skeptical attitude to life by the rules is overcome as a result of positive assessments of others or as a result of the positive experience of such relationship. The main meaning of the universality of rule of law lies in the purpose of or task, limiting arbitrariness of power. Tyrannical power is much worse than power limited by law and cultural norms. Therefore, it is necessary to potentially clarify and demonstrate these points. Ukraine has a legacy of disregard for the law and some traits of a national character that differ from, as to say, Germany or America. Three traits of the national character and the need to take them into account while waiting for the effect of reforms: emotionalism, desire for freedom, striving for changes in social forms. Emotionalism means predominance the feeling over reason. On the one hand, this complicated positive perception of legal order, and on the other hand, this should be taken into account because it causes a heightened sense of justice. The desire for freedom, it tends the desire for freedom, it tends to identify freedom as equality, but also produces a threat of rebelliousness of external conquest and external force as such. The third feature can be briefly described as a propensity to revolutions. The question is not only to know about the benefits of living according to the rule of law, but to make an existential decision not to deviate from this path. The key problems that most acutely confront states that are moving along the path of development rule of law are fight against corruption and formation of an independent and effective judiciary. Phenomena become especially unpleasant when these moments coincide. Unfortunately, we have recently experienced the acquisition of taking a large bribe from the former chairman of the Supreme Court, Knyazov. But can we observe any positive changes in these realms? Yes, we can. As yes. We have in the realm of judiciary that's positive changes. The activity of the new Supreme Court is a significant improvement over the old one, both in terms of the consistency of practice and the structure of decision, justification, and other. The activity of the new composition of High Council of Justice and the activity of the new composition of the High Qualification Commission of Judges of Ukraine, transparent competition with participation of Western representative, 30% of composition. In the field of combating corruption, activity of the High Anti-Corruption Code can be noted. There are real conviction and a fairly good public assessment, although major figures have not yet become defendants in anti-corruption cases. New opportunities are also opening up for the Constitutional Code of Ukraine, also not so effectively, the institution of the constitutional compliant normative has started to work. So I finished my report.
Thank you very much. Yes, we see how complex rule of law is in the perception and realization through institutional systems and through the jurisprudence. And no, I'm happy that you gave us this analysis. And yeah, now I would like to give the floor to the judge of the Constitutional Court of Kosovo, Ms. Remzi Istrefi-Peci. So.
Thank you so much. Dear Chair, respected panelists, ladies and gentlemen, participants, dear friends. I want to use this opportunity and thank Professor Reiner for everything that he has done to bring us here. Indeed, I recognize the value of the forum and the relevance for whatever it has done and it has achieved so far. But I think that today's event is of great relevance due to the fact that all of us, we are together here and trying to reiterate the relevance of the rule of law in today's world. Recognizing the relevance of 7-minute presentation, which I'm going to respect fully because the watch is just instead of me, I am going to present today on the topic, or my intervention relates to the rule of law in post-conflict societies, but I'm aware that I'm going to leave us many things unsaid, but I will try to focus my contribution on building the rule of law in post-conflict situations. During today's panel, I trust that the common denominator of all the presentations was the fact that at the international level, the concept of rule of law is promoted as a universal ideal applicable to all states, and that its ideological function and its association with other key concepts, rule of law has come to affect our very perception of democracy, constitutionalism, human rights, and the state in general. But I want to reiterate that this perception, in fact, in particularly takes a different connotation in post-conflict countries, which are characterized with violent conflicts, with human rights violation, war crimes, crimes against humanity. And in cases like this, the situation actually necessitates the fact that international community and all member states of the world should contribute to the post-conflict territories in order to build peace and prosperity. This theoretical prominence of the rule of law really has been tested in the case of Kosovo, which I just want to remember the fact that Kosovo has had a very difficult and painful past due to the 1999 war, which actually estimated that around 13,000 civilians were killed around 20,000 of conflict-related sexual violence victims has survived. Also, 1,600 people still are missing, and let alone the economic destruction and social trauma. So in this context, the rule of law concept and building a new state which is built on respect for human rights is more than relevant. So in this sense, I just want to turn my discussion to two crucial historical moments that have taken place in Kosovo, which have actually shaped the current legal order. At first, I want to point out the period of United Nations International Administration in Kosovo that was launched in 1999 through United Nations mission known as UNMIK, which governed territory of Kosovo for almost a decade. Later on, the second moment for sure is the declaration of independence of Kosovo in 2008. Why do I want to I'm doing this separation? Actually, it has to do with the relevance of the international efforts in helping post-conflict societies to build the rule of law after such a harsh conflict. And I think United Nations mission in Kosovo is such an example, because coming into a territory which was devastated actually with a total destruction of institutional and social life, and international community taking up in their hands the legislative efforts, judicial but also executive powers, have managed to establish in Kosovo such an institutional setup which paved the way actually for establishing an independent state which currently is trying to contribute to not only through building its peace, but also in the region and furthermore. So Resolution 1244 it actually is a very particular document, because it establishes the respect for human rights in a territory after such a long and violent conflict. However, with an enactment of the Constitution of Kosovo after the declaration of Kosovo's independence, what we have seen is the fact that a new constitution is building from the scratch the social life, institutional life, and other ethnic representation through allowing for the respect of rule of law. The term rule of law in the Constitution of Kosovo is mentioned several times, actually as a value, as equality before the law, but above all in two very large chapters of the Constitution, which is Chapter 2 and Chapter 3, which provides for very high human rights standards to be applicable in Kosovo, meaning that all the rights that are known currently through international standards are applicable for the citizens of Kosovo, let alone the fact that Article 22 of the Constitution of Kosovo provides for application of 9(b), actually, international agreements which provide for human rights protection. Also, Constitution of Kosovo is unique for the fact that it provides that all decisions within the judiciary in Kosovo will be in harmony with the jurisprudence of the European Court for Human Rights. So what I'm trying to say is that building up a rule of law system in Kosovo at first through the assistance of international community and later on through the domestic authority is not followed by trials and errors. Of course, we still face very many difficulties, but I just want to reiterate the relevance of the rule of law and also the lending hand of international community through their support. How can rebuild a society which has been faced through a harsh conflict, but above all, through a very repressive repression by the dictator Milosevic. So in that sense, I consider that forums like this one and the reiteration of the relevance of the rule of law and the contribution of each and every one of us will further enhance the rule of law system in the world and, of course, in our domestic territories. So I'll stop my presentation because I think I'm very punctual with the timing. Thank you very much again for this opportunity.
Thank you very much. Yes, you are right that rule of law is a matter of all of us. And yes, so it penetrates all the life, and but we are about to make a contribution for confirming and maybe consolidating a bit the rule of law, or bringing this idea outside, also transnational. So then I will give the floor to the last speaker of today, Professor Natalia Mushak. Let me first explain and thank you. Here is my co-chair. This is Professor Cristina Hermida de Llano from Madrid, Rey Juan Carlos University. And she was so kind to make something what is so important for us, to look for the United Nations passport for tomorrow. And this was a rather difficult matter, so she, thank you so much, dear Cristina, but you should here be on side, and yes, and thank you so much. This, I can say, I think you have been successful now. Okay, so these passports are, or the passes are now available. But this was only a remark in between, and so I give the floor.
Thank you so much, dear Professor. Dear participants of the Congress, dear friends, today's my address is focused to the EU candidate status, the rule of law and legal reforms in Ukraine. Ukraine is a rule of law state with age-old traditions and history. Nowadays, according to the Constitution of Ukraine, Article 8, the rule of law shall be implemented and recognized in Ukraine. On the 28th of February 2022, just a couple of days after the Russians' aggressions to the territory of Ukraine, the President of Ukraine, Volodymyr Zelensky, signed the application for Ukraine's membership in the European Union. I would like to stress your attention because this procedure was done according with Article 49 of the Treaty of the European Union that stipulates that any European state that recognizes the principle of fundamental rights and respect to rule of law may apply for membership in the Union. The application for Ukraine has been carried out according to the accelerated procedure. What does it mean? It means that the Council didn't inform the national parliament. It happens and it takes only 3 months to get the candidate status instead of a lot of other months that it was in case of other European states. At a summit in Brussels on the 23rd of June 2022, the European Council decided to grant Ukraine the candidate status to the European Union. And to my mind, this day has become the historic day in the history of Ukraine and its further development. However, before Ukraine becomes engaged in the negotiations on the conditions of admissions, Ukraine has to implement some requirements. What actually are the main problems to fulfill the requirements? The first one is the constitutional problem. Unfortunately, but during the 30s of the independence of Ukraine, the constitutional problem is still on the top of problems in Ukraine. Nowadays, we are talking about the selection of judges of the Constitutional Court of Ukraine, which is about the number of members of the advisory group of experts, the principle of voting, and the principle of assessing the competence of the judges. The second problem is the implementation of so-called anti-oligarch law. The anti-oligarch law was adopted 2 years ago, in 2021. It envisages the creation of the register of the oligarchs, but at the same time, it caused a lot of criticism of the procedures and criteria. The authorities could use this law like to punish inconvenient businessmen, politicians, instead of ignoring their own one. Thus, the main idea that the law should pass the Venice Commission assessment before implementing into Ukraine legislation. Till now, Ukraine is unable to fulfill this criteria. It means that the European Commission must clarify this criteria, or the EU must decide that it will not consider it when deciding to start negotiations. The third problem, and I must clarify that Ukraine has exceeded the success in this, the third point, this is the appointment of a new head of the Specialized Anti-Corruption Bureau of Ukraine and Specialized Prosecutor Office. Nowadays, Ukraine has already fulfilled it. The fourth one, and unfortunately, but the fight with corruption that has already been mentioned by Mr. Meyer in the beginning, it's like also the second problem when we're comparing other problems. And now Ukraine, in regard of the war, also highly demonstrates the level, the increasing level with fighting of corruption. The fifth one is the judicial reform. The Plenipotentiary High Council of Justice has recently started working, and the competition for the re-election of this member continues. Just to sum up and to make some conclusions. The simplified and rather accelerated procedure for granting a candidate status to Ukraine resulted from the recognition of Ukraine's leading role in protection the core values of the EU on the battlefield against Russian encroachment on freedom and independence of Ukraine and the whole Europe. In order to help Ukraine to meet the Copenhagen criteria, it may be required to implement a number of the EU Commission recommendations. Only after their implementation, a candidate state may be engaged into the negotiations. And the last one, even if an applicant country meets and fulfills the political, economic, and legal requirements, the biggest challenge is the political will of EU member states. Unfortunately, but the history shows that the political will of the EU member states predetermined almost all decisions on the expansion of the European Union. Thank you very much.
Thank you very much, dear Natalia. This is a look at the future, and I do my best wishes for the way of Ukraine to European Union. So I want to thank all of you, the speakers, the audience, and for listening to us, for reflecting together with us. And well, we are optimistic as to rule of law, I think. And let's go now with this idea and wish that rule of law is really a pillar of our life. It's because political life is intruding in personal life, and of course, so rule of law, I think, is, as one of my friends, Anthony Bradley, said in Regensburg, one of my conferences long ago, rule of law is a secular religion. And so, yes, these are, I think, in my view, the anthropocentric, the human being-oriented rule of law is something what will survive, and even against political, let's say, political troubles and tournaments. And yes, in this sense, I thank you. I wish you all the best. I hope we see each other tomorrow, United Nations. And I want to say I will write you on the publication. It will be published in Springer International, and yeah, we would like to have some manuscripts end September. Is maybe, I'm not sure if this is feasible, but I will write you, and then we will see. Good. Many, many thanks. Adieu.